Hi, I'm Janice Switlo, and today I want to touch again upon a little bit of information regarding reconciliation. And I'm going to read to you some excerpts from legal opinion, basically a case study done by some lawyers at Borden Ladner Jervis LLP, which is where I actually first learned the practice of law. It's titled, this came out in May 10, 2017. It's titled Canada. Alberta Court of Queen's Bench quashes Alberta's refusal to transfer or sell subsurface land rights to a First Nation band. Now this concerns the Blood Tribe and Treaty 7, and the decision is, Blood Tribe versus Alberta. If anyone's interested, the site is 2017 ABQB 107. And the case comment in saying, well, what are the implications of that? And here's where it's discussed how the court sees reconciliation as defined by, in the domestic arena, if you will, as defined by Canadian policy and by decisions of the court. Blood Tribe is significant to administrative decision-making involving First Nations rights and entitlements. First, the court highlighted the constitutional mandate, that's Section 35, doctrine, the constitutional mandate on decision makers to consider the role of the decision in facilitating the ultimate reconciliation of prior Aboriginal occupation with de facto Crown sovereignty, bracket, the process of reconciliation, close bracket. Second, the court held in obiter that the honor of the Crown extends to the nature and manner of communications with the band. Communicating reasons to the band is a sign of respect and the requisite comity and courtesy of the Crown as sovereign toward a prior occupying nation. This doctrine, I'll call it a doctrine of reconciliation because it is coming out in the courts now. It's part of Section 35. It's linked with that. Is really reversing the actual fact on the ground as proven by the treaties. Now remember, this is Treaty 7. Treaty 7 also contains, as other treaties do, the boilerplate provisions that you find in leases to have and to hold, that sets out and confirms who the landlord is, who the tenant is, and for how long. And under treaties, it's forever. There's no the provision for termination or a set amount of time, as you would find in a modern lease, for example. That, by definition, by those very words, recognizes the sovereignty of the nations referred to in the treaties, and in this case, the Blood Tribe. They're not just occupying. They are not beasts of the field. When that treaty was entered into, the Crown specifically referenced and recognized and respected the fact of Indigenous sovereignty, the fact of nations. It's only through the doctrine of discovery, beasts of the field, upon which the Section 35 doctrine is based, that we see these convoluted things of a prior occupying nation. The treaty's not dead. It's still alive. The nation's still alive. And this concept of de facto Crown sovereignty. No, the Crown was provided with certain provisions, certain permissions under those treaties that allows her to exercise certain partial political sovereignty. She is not. And of course, this de facto, the court is, in, as these lawyers set out, is admitting that the Canada, Alberta, they're going past that. They're saying, well, we want this, so we're going to just act like we have it. That is not a country that is governed by the rule of law. A country that's governed by a rule of law would always respect the actual facts as contained in the treaties and respect the actual continuing sovereignty and nationhood of, in this case, the Blood Tribe. But instead, this court is referring to them as something prior, occupying. Occupying is beasts of the field terminology. And again, Treaty 7 puts that to rest. That notwithstanding the existence of the doctrine of discovery at that time, that the Crown chose to recognize the nations and their sovereignty and their land holdings and respect that and seek only to become the head tenant. So this Section 35, which I've said time and again is bad law, because going back to then Chief Justice Lemaire, who just decided to write in a new provision in the Constitution. We can't do constitutional amendments like that, even after 1982. And it just keeps building. And to say that that's what reconciliation is about, Indigenous nationals need to really understand that if you use that term now, if you say, okay, we want to be part of this reconciliation, if you throw that in your agreements, and this word's coming everywhere, remember, it's defined in domestic language, in courts, in lawsuits, in case decisions. So you're taken to be accepting that you are just an Aboriginal occupation on your land, not this is your land. So I caution you, I remind you, reconciliation is just more of the same. And in principle, after you've had apologies, for example, with residential schools, a reminder that in Canada there's legislation that says, well, if you apologize, it doesn't matter, you're not accepting liability. So it's quite frankly easy to apologize in Canada for governments and anyone coming to visit, for example, a pope. The reality on the ground is, what are their actions conveying? If they are sincere in their apologies, they are understanding their wrongdoing and they won't repeat it. They won't keep building upon it. And that's exactly what Canada is doing. And that's exactly what the domestic courts are doing. And Indigenous nations do not have to accept that. You have your treaties. Maintain your nationhood, act as the nations, and therefore preserve your treaties, because that confines and binds the Crown and in turn her governments in Canada. And that's all I have to say.